Thank you. Good afternoon. How statute law is made. Law has a number of different sources. The academic study of law, on which many of you are just now embarking, very often concentrates on one particular source, so-called judge-made law, the development of principles on a case-by-case basis. You're likely to spend many hours in the next few years trying to draw the principle from a series of detailed and often perhaps seemingly inconsistent judicial pronouncements. However, there is another very significant body of new law that emerges every year from another source, Parliament, and seeks to set out the rules in clear, concise terms. That source is statute law, Acts of Parliament. For you, statute law will appear in your studies as a parallel set of rules, sometimes setting out the law, often supplementing law from other sources, and nearly always with priority over it. UK statute law has a greater or lesser impact on almost every area of law you will study, but it is made in an entirely different way from judge-made law, not in an empirical, case-by-case way, but in a more abstract way, analysing many possible permutations a priori in a way that brings the political world and the legal world into close and cooperative contact. I'm here to tell you about the process by which statute law is produced, and also about those of us, the Parliamentary Counsel, who are most closely involved in it as lawyers. As such, we follow a discipline which is different in many respects from the one which you will be following as law students, and which most practicing lawyers follow. You and they have the task of searching for the line that is drawn by the law. Indeed, the theory of judge-made law itself is that the judges are really only finding it, not making it. A lawyer's clients want to know how to stay on the right side of the law, whether they have crossed it, and some perhaps how to get as close to it as possible. The job for the drafters of legislation involves us instead in actually drawing the line, and drawing it on a clean sheet of paper with relatively few inhibitions on where it goes, except, of course, the policy of the government. The doctrine of the sovereignty of Parliament means that Parliament can do what it likes, although European Union law and the European Convention on Human Rights do now provide some legal constraints. I myself have been involved in a bill not so long ago that deemed references to 3 days in March 2007 to be, and always to have been, references to 3 days in May that year. It was christened the TARDIS Act by some commentators. For us, the law is not a fixed point, but a variable in a complicated equation in which there are also many other variables which have to be balanced to produce the policy outcome and the legal result wanted by the government and by Parliament. I'm the head, as you've heard, of the Office of the Parliamentary Counsel. The office, established in 1869, when it was office in the sense of a post for a job, subsequently became a corporate body, a collection of people, and also, of course, has a building. So 3 meanings of office, which from my career you'll appreciate is something that I'm interested in. The office is located within the Cabinet Office, where I serve in civil service terms as the permanent secretary of the office. And there are 3 legal permanent secretaries in the civil service. There is the Treasury Solicitor, who is the head of the profession for the Government Legal Service and responsible for civil litigation with the government, the Director of Public Prosecutions, whose functions are obvious, and then there's me, who has quite the smallest command. My office consists of some 50 or 60 lawyers who are not members of the Government Legal Service, and we have about 20 support staff who help us with our work. Our main function is to prepare the bills, the proposed Acts of Parliament, that make up each session of Parliament, the government's legislative programme. We also have a role, a subsidiary role, in relation to some statutory instruments, but our main work is on Acts of Parliament. The difference from normal legal practice that I've described, and our position on the boundaries between policy and law, are manifested both by our location within the Cabinet Office at the centre of government, and I also have personally 2 other relevant functions. I advise the Cabinet Office on certain constitutional and parliamentary matters, and I'm also ultimately responsible for the management of the civil servants who support the government's parliamentary business managers, who are ministers. I'll come back to that, but the government's parliamentary business managers are the leaders of each house, the leader of the House of Commons and the leader of the House of Lords, currently Sir George Young and Lord Strathclyde, and the chief whips in the two houses. And they are supported by a number of other whips and have deputies who, under the coalition government, are Liberal Democrats. But as I've said, the main job of the lawyers in my office is to produce the government's legislative programme. That's a responsibility I owe, ultimately, to the Prime Minister, but in practice, I do work to the government's parliamentary business managers, whom I've just described, and to the Cabinet Committee chaired by the Leader of the House of Commons. This is now known as the Parliamentary Business and Legislation Committee. It's been known as other things under previous governments. And the committee has all the parliamentary business managers and their deputies as members, and also other ministers who are interested in the progress of the government's parliamentary business and in particular legislation. That line of responsibility, though, to the parliamentary business managers is not the only line of accountability for the Parliamentary Counsel. The government's legislative programme consists of all the bills from different government departments introduced in a particular session of Parliament. When a department wants a bill and is awarded a slot in the programme, first of all by the Cabinet Committee and then confirmed by the Cabinet itself, I allocate a team of drafters to that bill. The drafter in charge of each bill is then accountable to the minister in charge of the department for the production of that department's bills, but still, of course, as part of a single programme of all the legislation the government wants in a particular year. And the Parliamentary Counsel also have a third responsibility. As government lawyers, they are responsible for drawing questions of legal policy affecting bills to the attention of the law officers of the Crown. There are currently 3 law officers of the Crown: Attorney General for England and Wales, Solicitor General for England and Wales, and the Advocate General for Scotland. These issues might include issues relating to the rule of law, such as proposals for retrospective legislation or for the early commencement of legislation. This is a responsibility that's usually discharged through briefing the law officers for the Cabinet Committee that I've already mentioned. The Attorney and the Advocate General are members of that committee, and the Solicitor General may attend on behalf of the Attorney. So, those are the responsibilities as background. What do the Parliamentary Counsel do, and how does this all result in statute law? I want to deal with 3 stages in the production of statute law. The Parliamentary Counsel are involved to different degrees in each of them, and indeed also in a 4th stage, which I shall mention, which does occur in most cases, where the statute law, where the Act of Parliament has been passed and has already reached the statute book, is brought into practical effect. The implementation stage can take almost as long as getting the bill through Parliament. But the 3 pre-enactment stages are the planning stage, the policy development and drafting stage, and the stage of getting the bill through Parliament. So starting with the planning stage, I want to say something first about how the government's legislative programme is planned. Before I do, however, I need to mention some changes that are currently taking place. The coalition agreement, the agreement between the Conservative Party and the Liberal Democrat Party, which forms the basis of their current cooperation in government, provides for the establishment of fixed-term parliaments of 5 years. This will replace the current system, under which a parliament can last for a maximum of 5 years, but can be brought to an end earlier than that, triggering a new election, effectively whenever the Prime Minister chooses. The proposal is that, with certain carefully defined exceptions, an election will be held on during every 5th May, with the next election being held in May 2015. A bill is currently passing through Parliament to achieve this, and it will have the effect of changing the pattern of legislative activity which has prevailed until now. The government has already announced that this change will involve a change in the current Parliament to annual sessions beginning and ending in the spring. By way of transitional arrangement, the current session of Parliament, which began in May, just after the election, is to continue until spring 2012. So there will be, to start with, a 2-year session of Parliament. The previous pattern had been to have a Queen's speech beginning a session and announcing the government's legislative intentions in the November of each year, except where there was an election year, when it would take place in the May, or immediately after the election. In recent decades, elections have tended to take place in the spring. The change to fixed terms that is now proposed means the way that a legislative session is likely to be planned in future will change, and what I say must take account of that. What is a parliamentary session? Parliamentary business over, say, a 5-year parliament is organised into shorter periods, and the shorter periods are known as sessions. These are assumed, in normal cases, to last for about a year, although in practice the previous system resulted in a long one at the beginning of a parliament and a short one at the end. The underlying assumption is that any business that is begun in one session must be ended in the same session. There are exceptions to that rule, but despite the exceptions, it is that assumption about finishing business in the same session as you begin it that determines how the government plans its proposals to change the law, its legislative programme. One of the most important factors that the government has to take into account when planning legislation is the amount of legislative time in both houses that is available for the discussion of legislation. Taking into account all the other things Parliament has to do over a year, time for legislation is quite limited over a 12-month period. This is true even though almost all the time that is available for legislation in Parliament is used for government legislation. The procedures for getting a bill through, which I shall come to, are capable of using up a considerable amount of time on a single bill. In addition, there are conventions that govern the minimum amount of time that should normally be taken between the different stages of the proceedings on a bill in each house. In recent years, governments have tended to confine the legislation passed in a single year, in a single year-long session, to between only about 20 or 30 bills. The government does not have the opportunity to pass as much legislation as it likes. It is severely limited by these time constraints. And another important factor that affects planning is the need for the government to get its legislation through, and that means through both houses and the House of Lords in particular. It's in the nature of our Westminster parliamentary system that the government does, almost by definition, have a majority and therefore significant control over the passage of business through the House of Commons.